Hey folks, this is an ERISA Supreme Court update for June 2020. I'm going to start with Thole, the U.S. bank. This is a relatively important decision, but I want to start with my usual disclaimer that this is just educational purposes and not legal advice, not financial advice, and that all opinions are mine and they're not anybody else's opinions. I'm going to hit these four Supreme Court cases. One of them is actually refusal of cert, but I'm lumping it in because I think it's really important. But we're going to start with this top one, Thole v. U.S. Bank, which is about defined benefit pension plans and the right of participants to sue. So let's jump in. I'm going to go through the overview, the facts of the case. I'm going to hit some of the issues on fiduciary duties, and then the actual outcome with the court, opinion, concurrence, and the dissent, and then analysis and some of my commentary on the future that this foretells. So as an overview, it's Thole, the U.S. bank. Plan participants were suing the pension plan for U.S. Bank. They were suing the fiduciaries over investment decisions. So it's important to remember the participants had received all the pension plan benefits that were due to them, and that the plan was fully funded at the time of the Supreme Court decision, and that therefore any better investment outcome would not have increased benefits paid to the participants. That's important to understand. So the question is, can they sue if they weren't harmed because they got all their benefits and recovery wouldn't help them? Because again, recovery would not go to them. So it's an interesting legal question. Can you sue even though you weren't hurt and you wouldn't be helped if you won? So let's dive in a little bit to the facts of the case, and you could really get buried in these. But let's, at a high level, before the 2008 Great Recession, the financial crisis, the plan trust was almost entirely invested in equity assets. And before the Great Recession, the plan was overfunded because these equity assets had excellent investment returns. And then the financial crisis, Great Recession, the plan trust lost a significant amount of value and ceased to be overfunded. It was a little bit underfunded, as low as 84% of liabilities. So that's more than enough to pay current liabilities, all the benefit payments that need to be due now, but it means that actuarially it was not expected to have enough money to pay all the benefits years out into the future. And that's due to the market crash. Post 2008, the plan trust was allocated about a quarter to fixed income and real estate. The plan eventually recovered in funding and it became fully funded, both contributions from US Bank and investment returns from the economic recovery. So one of the claims by the plaintiffs, who were plan participants, was imprudence, or a failure of the fiduciary duty of prudence. The plan trust lost almost $750 million around the Great Recession and the financial crisis due to investment decisions, at least that's the claim, and that allocating almost entirely to equity, what they called the 100% equity strategy, resulted in significant losses in 2008. Now, of course, those losses would have been mitigated if the trust had been diversified, if there had been not fewer than 100% equities, typically fixed income instruments like bonds. They would not have suffered nearly as much as equities. So the allegation is that this violates the ERISA fiduciary duty of prudence, and implicitly it would also potentially violate the duty of diversification. So there's also a question of disloyalty or a violation of the fiduciary duty of loyalty. FAF was at the time, during some of the time at issue, was a subsidiary of US Bank. They were sold to Nuveen, an investment company, in December 2010, but plan fiduciaries for the US Bank pension plan made FAF the investment manager of the plan, and FAF invested up to, at times, 40% of plan assets in FAF's funds. So fees from the plan went to FAF. FAF was the investment manager and it was also the fund. So FAF's advice to the plan was that it should buy funds from FAF. So that's where the allegation comes from, that this was a violation of loyalty and essentially self-dealing, and that not only was it self-dealing, but that obviously the fees were unreasonably high, basically, FAF wanted the plan to pay more just to enrich itself. So the plan was made worse and FAF was made better. And that would obviously violate the ERISA fiduciary duty of loyalty. That would be disloyalty. There's also the issue of overconcentration, which is a violation of the fiduciary duty of diversification. Now, ERISA actually lists the duties of prudence and diversification separately in Section 404A. They're two separate duties. Traditional trust law does not usually do that. Diversification is typically treated as a duty of prudence issue. And the plaintiffs in Thole, for whatever reason, did not claim a specific separate failure of the duty of diversification. But at root, they are making an overconcentration claim, even though they present only imprudence and disloyalty. Implicitly, it is also overconcentration. That doesn't actually open up any different avenues for recovery, so it doesn't matter. But if you're interested in ERISA litigation or defending against ERISA litigation claims, it might be interesting to note. So let's jump into the outcome. What was the opinion of the majority? So as of June 1st, 2020, the opinion was released. It was written by Kavanaugh, the newest justice, and it was joined by the conservatives, so Roberts, Thomas, Alito, and Gorsuch. So meaning it's a 5-4 decision, and it was decided against the participants and in favor of the plan fiduciaries. And in a nutshell, they just said there's no injury to participants and no recovery would actually go to the participants. So the plaintiffs must lose, right? There's no harm. They got all the benefits due to them. And no recovery is available because even if the plan were overfunded, if this lawsuit won, if U.S. Bank had to make a large contribution to the U.S. Bank pension plan, the remainder would eventually go back to the sponsor, would not go to the participants. So the majority opinion just said there's no standing. You don't have any standing. You were not harmed, and recovery wouldn't go to you. Primarily, it probably turns on the harm issue, but I think the recovery helps drive home that this is not something they wanted to offer or find standing for. And then we had a concurrence, which was by Thomas, and it was joined by Gorsuch. This is just sort of an interesting point of ERISA litigation jurisprudence, right? So Thomas has said this before, but basically that trust law is an inappropriate analogy or an inappropriate framework for considering ERISA cases. And this is an ERISA case, of course. So that would be that the participant has a legal right to plan benefits, but not a right to plan assets, to the assets of the trust of the plan. And Thomas also says that ERISA defines fiduciary differently from the trust law definition, which is true. ERISA has its own concept of fiduciary, and it is dictated in the ERISA statutes and the ERISA regulations. So Thomas has been on this sort of hobby horse. He's had this perspective for 2.5 decades. And there's a famous case, Verity Corp v. Howe, and he was joined in dissent from that case with Sandra Day O'Connor and Justice Antonin Scalia. And it is interesting that the Thole majority did not adopt this perspective exactly, but they were using more of a contract law analysis than a trust law analysis. Fundamentally, the payments were made as required, and that the fiduciary issues don't matter because there's not a contract violation. Kind of, an interesting little point if you're trying to understand more about ERISA litigation and how it works. But the majority did not actually agree with Thomas, although they do seem to have been influenced perhaps by a similar perspective. And then the dissent, which is probably much more relevant if you're looking at future outcomes on cases like this and what an alternative might look like. It was written by Sotomayor and joined by the liberal justices Ginsburg, Breyer, and Kagan. And they thought that the disloyal acts alone were sufficient for standing, did not need to show harm, did not need to show recovery, and they thought that it didn't matter whether there was a trust law or a contract law framework in place, that the participants need to have a remedy in case there's mismanagement by ERISA fiduciaries. So that is probably more likely to be seen in a future majority opinion than Thomas's concurrence. Um, so an analysis, what does this mean for today? What, in practical terms, what does this mean right now? It's probably harder to sue pension fiduciaries unless there's a failure to receive the benefit payments when they're due. That's probably the most important thing that it means. And the expectation when this was coming up, bubbling up through the courts, was that it would turn on funding status and whether you could sue a fully funded plan. The lower courts thought that that mattered, but it did not end up mattering in the majority opinion. They did not turn on that at all. But it's important to remember the majority didn't just immunize defined benefit pension plan fiduciaries from all claims, uh, but they did make clear that some kind of actual harm, like a lack of missed payments, that would matter for standing. But only a relatively small number of DBs will actually fail to pay benefits when due. That would generally be like a crisis situation. That's pretty uncommon for most plans. So it does seem to certainly narrow when a pension plan fiduciary can be sued. And then commentary, which rather than analysis, I'm trying to speak more currently. What does this mean right now? And commentary, I'm thinking, what does this mean for the next few years? What does this mean for 10 years plus from now? I would suggest that maybe Thole is a little more vulnerable to future changes than some other Supreme Court decisions. It's a little bit um, more to the extreme on one side, basically against plaintiffs and in favor of plans. And just as a general rule of thumb, whenever a decision seems to really favor one side in a controversial issue, you should be cautious that the pendulum will swing back. So I wouldn't be surprised if future cases, whether Supreme Court or a lower court, could identify more contexts where a pension fiduciary could be sued, especially for disloyal acts. So I think pension fiduciaries should still be careful. The subtext here is that the plaintiff's bar would be the main beneficiary of suing pension fiduciaries, and that was mentioned in certainly a lot of the commentary. It was mentioned in the actual court decisions and opinion that a large amount of money would go from the sponsor to the pension plan, and ultimately it would then it would not actually help the participants. It would reduce future sponsor contributions to the plan. So US Bank would basically pay a bunch of money now, but they wouldn't have to pay it in the future. Uh, the main beneficiary would be that the lawyers would be able to take a big chunk for attorneys' fees. So that's a big part of uh, why this might be a risk, is that even if participants wouldn't be better off, plaintiffs' attorneys could be improved by it. So it's important to recognize that subtext. That's why it does matter, even if recovery is not possible. The plaintiff's bar is still incentivized to care because attorneys' fees. Long term, I think 20 years, 30 years plus, this doesn't will increasingly be irrelevant because of the decline of pension plans and defined benefit plans and the rise of defined contribution plans like 401k. Thole will just be less and less important. Uh, but I do think in the interim, the pension crisis could mean this actually does become quite important. There could be a lot of conflicts over the mismanagement of pension assets. So uh, long term, it might not matter, but midterm, it might become important if it blocks participants from getting recovery. So takeaways, just at the highest level, Thole v. US Bank really suggests that it's going to be harder to sue a pension plan, a defined benefit pension plan fiduciary, as long as they're paying all the benefits when they're due. And that it doesn't even matter whether it's fully funded. Now, maybe a future case will come along and change that, but right now it doesn't even seem to matter. Uh, I think cautious fiduciaries should still be very careful. Just keep your head down and keep focusing on your ERISA fiduciary duties. Keep focusing on funding. Might not have mattered in Thole, but keep fulfilling those fiduciary duties and keep your plans funded. That's probably still the safest thing to do, just in case the pendulum does swing back. So, uh, but it is a very interesting case. I'm going to try to hit these other cases that have also come up. And again, one of them is actually not a decision, an opinion, but it was a refusal of cert, which ends up being incredibly important. Go through all of those and see what we can glean from this year from ERISA litigation. So that's a pretty interesting subject for me. I don't know where other people are on it, but I always like learning ERISA litigation. I think if you are looking for a framework for how to think about ERISA litigation, my opinion is fiduciaries should always watch litigation on ERISA, understand what it is courts are doing, because that is the best way to fulfill your ERISA fiduciary duties in good faith. It might seem like you're just looking to defend yourself against lawsuits, but it's also the best way to understand how to fulfill your duties, how to know what you're meant to do, know what you're expected to do, and follow those in good faith. So I think what Thole helps you learn is, even though you might be immunized from actually being sued, it is worth reading what was the claim here, the disloyal or potentially imprudent act. So even if what you take away from this is you can't be sued, you should still look what was the underlying problem here and what can your plan do to avoid causing those problems, even if you now are at lower risk of being sued. So, um, food for thought if you're a plan fiduciary or if you're an advisor to a plan. I hope that was helpful and interesting to you, and I will get with the rest of the Supreme Court update shortly. Thanks.